Thank you very much, Professor Lichovsky, on this amazing spread of history. We'll take our second speaker now, and then we'll have a conversation later about both lectures. I'm pleased and honored to introduce our second speaker, Dr. Haim Shapira. Dr. Shapira is senior lecturer at the Faculty of Law at Bar-Ilan University. He was the chief editor of the Journal of Law, Religion and State and the Hebrew Journal of Jewish Law. He authored numerous publications in Jewish studies, philosophy, and law. He will speak about Israeli law and Jewish law, human dignity, Kevod Adam and Kevod Ha-briyot. Please.
Since the enactment of basic law, human dignity and liberty, human dignity, Kevod Adam, became the central concept of Israeli constitutional law and human rights discourse. In this lecture, I seek to explore the possible and actual relationship between Israeli law and Jewish law regarding this concept. I will present a debate about the possibility of using Jewish law in this context and examine two different models which were introduced by two Supreme Court justices of the relationship between Jewish law and Israeli law regarding human dignity. I will start with some general remarks on human dignity. The concept of human dignity has a long history, but it became part of international and domestic law only after World War II. The first significant document in which human dignity was mentioned is the UN Charter from 1945, and afterwards, the Universal Declaration of Human Rights from 1948. Article 1 of this declaration provides that all human beings are born free and equal in dignity and rights. Following these documents, the concept was transferred to the domestic law of several countries. Even in countries in which their constitutions do not mention human dignity, judges and courts use this term from time to time. The concept of human dignity is obscure. The main question that occupies scholars is simply, what does it mean? What does it add to human rights? And if it adds something, is it good or bad? To begin understanding this concept, one has to discern that human dignity has a double function and a double meaning. According to one view, human dignity is the foundation and justification of human rights. Human dignity requires respect to human rights. According to this meaning, human dignity includes all human rights, but has no specific content of its own. According to an alternative view, human dignity indicates a specific right. Some constitutions contain a specific provision regarding the right to dignity. In this context, dignity is not a general principle which includes all other rights, but is a particular right which stands alongside all other rights. Most scholars assume that the substance of this right is protection of one's dignity against degradation and humiliation. Israeli basic law, human dignity and liberty, demonstrate the use of these two notions. The first meaning finds expression in the name of the law and its purpose article. The purpose of this basic law is to protect human dignity and liberty. Here, human dignity is a fundamental principle that includes many other rights, which are not mentioned in this article. The second meaning finds its expression in Article 2 and 4. It's sufficient here to cite Article 4. Every human being is entitled to protection of his life, body, and dignity. Here we see dignity is not a fundamental right, which includes other rights, but a specific right alongside the rights to life and body. One could assume that the meaning of this particular right is that every human being is protected from being degraded and humiliated. But the Israeli Supreme Court did not take this path of interpretation. Instead, it interpreted this right to dignity in a broad sense, as a general right which includes all other rights. According to this interpretation, the content of the right to dignity in Article 2 and 4 is similar to the value of dignity in the purpose article. In his book on human dignity, Professor Barak defines the right to dignity as a mother right that includes many daughter rights. In fact, it includes all other rights, those which are mentioned in the basic law and those which are not mentioned therein. The purpose of this interpretation is clear. The list of rights in Israeli basic law is partial, and many rights which are expected to be in the Bill of Rights are missing from it. The court sought to expand the list and include all other missing rights in the basic. The bottom line is that the Supreme Court interpreted human dignity as a fundamental principle that includes all human rights and in fact is identified with human rights. When people look for human dignity in Jewish law, they usually point to the concept of Kevod Ha-briyot. Kevod Ha-briyot can be translated into English as human dignity. And no doubt there is affinity between Kevod Ha-briyot and human dignity. But the equation is only partial. In rabbinic and halachic sources, Kevod Ha-briyot functions as a specific right to dignity. It does not function as a broad fundamental principle, as a sort of master principle which includes all human rights or all commandments between man and his fellow man. So the question is the following: does Jewish law recognize human dignity as a fundamental principle? Certainly Jewish law recognizes the special status of human being and the worth. But the question is whether it recognizes it as a fundamental principle, a principle which judges and halachic authorities would turn to and apply when dealing with legal and halachic problems. Professor Yitzhak Engelhardt, a former Supreme Court justice, published a scholarly essay on human dignity. In this essay, he argued that Jewish tradition did not recognize the value of human dignity. He drew a sharp distinction between human dignity and Kevod Ha-briyot. The concept of human dignity expresses the intrinsic value of human being. The concept of Kevod Ha-briyot, he argued, does not recognize such an intrinsic value. Rather, the worth of human beings depends on the fact that human beings are created by God. God granted humans the worth and honor. In other words, the secular concept of human dignity is anthropocentric, whereas the Jewish concept of Kevod Ha-briyot is theocentric. This distinction implies that one may not equate Kevod Ha-briyot to human dignity, and a judge should not infer from the Jewish sources to legal concept of human dignity. Needless to say, Justice Engelhardt, as a judge, never turned to Jewish law in cases of human dignity. The position of Engelhardt echoes the position of Yeshayahu Leibovich regarding the relationship between Jewish faith and humanistic values. Leibovich emphasized that Torah and commandments, Jewish values, concern worship of God and not the service of men. Humanistic values concern the welfare of mankind, or in Leibovich's words, the service of men. Following this distinction, Engelhardt includes Kevod Ha-briyot in a commandment, Kevod Ha-briyot is a commandment and not a humanistic value. The underlying assumption of Leibovich and Engelhardt is that observing the commandment is a matter of obedience to the authority of God, and that matter only. Given this premise, the content of the commandments and their rationale have no significance. This understanding can, of course, be disputed. If one endorses a different approach, in which the content of the norms, the nature of the commandments is significant, then one can see the affinity between human dignity and Kevod Ha-briyot. In contrast to Engelhardt model of separation between human dignity and Kevod Ha-briyot, I will introduce a model of comparison and absorption of Jewish law. As one could imagine, the best example for such a model can be found in the judgments of Justice Menachem Elon. Justice Elon developed a systematic and coherent conception of human dignity based on Jewish sources. This conception can serve as an alternative to the common version of human dignity, and in an interesting way may take part in the current global discussion of human dignity. As far as I can tell, this aspect of Elon's judicial philosophy was not appreciated properly yet, so it is an opportunity to start doing it. Let us start with the concept of human dignity. To recap, it is a real question whether Jewish law contains a fundamental principle of Jewish dignity. The structure of Jewish law is as a regime of rules. It does not contain any list of fundamental principles at higher normative level, including a broad concept of human dignity. In modern legal system, however, fundamental principles are conceived as necessary component of the system. As legal thinking became less formalistic and more dependent upon principles and values, the existence of fundamental principles became vital. Given this climate, one can understand Elon's efforts to identify or discover fundamental principles in Jewish law. As part of these efforts, he espoused the fundamental principles that can be viewed as a Jewish alternative for human dignity. In the Naiman case, 1984, the case which dealt with the eligibility of Rabbi Kahana Party Kaf to participate in the election to the Knesset, he wrote the following: a founding foundation in the world of Judaism is the idea of creating man in the image of God. The Torah of Israel opens with this idea, and Halacha draws from it several principles relating to the worth of man. Every man, whoever he is, equality and love to every human being. Just as Elon's statement, the Jewish law recognizes the equal worth of every human being, whoever he is, echoes the first article of the Universal Declaration of Human Rights. Elon based that principle on the idea of the creation of man in the image of God. And it is from this that he derived the Jewish version of human dignity. He would repeat this principle in many other cases. All human rights are founded in the idea of creation of man in the image of God. Here are some examples. In a case from 1987, which dealt with the grounds for detainment, he stated, "Our sages taught us, beloved is man that was created in the image of God. This fundamental value in the world of Judaism is the basis, the heart of the principle of human freedom." In this case, God's image is the basis for human freedom. In the case of Haim Shapira, he connected the idea of God's image to sanctity of human life. In the image of God, he created man. This is the theoretical and philosophical foundation for the unique approach of Jewish law to the supreme value of sanctity of human life. It is the sanctity of the image of God by which man was created. In the case of Goethe, 1992, he declared, "The founding foundation of the supreme principle of human dignity is that man was created in the image of God." The term human dignity in this passage refers to the right to dignity in its narrow meaning, namely to the right to be protected from humiliation. In any event, the source of human dignity, according to Justice Elon, is God's image. This is only partial list. In many other cases, Elon would repeat this idea: all human rights are derived from the fundamental value that man was created in the image of God. It might sound natural to our ears, but in fact, this formulation is Justice Elon's innovation. The classical codes of Jewish law, Maimonides to Shulchan Aruch, did not mention the image of God as a fundamental principle. As far as I can tell, not any other earlier or later authorities from the Rishonim and Achronim did so. To espouse this idea, alone had to go back to Talmudic and Midrashic sources. But also, in these sources, it is not presented in this way. Yair Loberman demonstrated the centrality of the idea of God's image in rabbinic legal thinking. He showed how it shaped the ways of execution and how it determined the rabbinic objection to capital punishment. Yet, his findings don't exhibit God's image as a foundation for all the commandments between man and his fellow man, or in modern language, for all human rights. Justice Alon cited Rabbi Akiva's statement in the Mishnah, "Beloved is man, for he was created in the image of God." But the implications of this general statement are not clear at all. It does not say that this idea is the foundation of all the commandments. The rabbinic source that can establish this idea in the best way is the well-known dispute between Rabbi Akiva and Ben Azai in the Sifra, the Tanaitic Midrash on Leviticus. Love your neighbor as yourself. Rabbi Akiva says this is a great maxim of the Torah. Ben Azai said this is the book of the genealogy of Adam is a greater maxim. According to common interpretation, Ben Azai states at the end of this verse, he made him in the likeness of God. If so, Ben Azai expresses explicitly the idea that image of God is the fundamental principle of the Torah, presumably the part of the Torah which relates to the commandment between man and the fellow man. But it is not clear at all that this was a consensus view among the rabbis. Rabbi Akiva apparently had a different view. So after all, the statement that the image of God is the founding foundation of all human rights is Justice Alon's innovative formulation. I do not intend to say that Justice Alon picked implausible principles. To the contrary, he really pointed to the biblical foundation of human dignity. But the fact is that halachic sources did not mention it as a fundamental principle. Justice Alon identified this idea and established it as a Jewish alternative to human dignity. Now we should ask a similar question that we have asked at the beginning of this lecture. The concept of God's image is obscure. The question is simply, what does it mean? What does it add to human rights? Here the question is even harder, because the idea of God's image is a mythical concept. It seems far away from modern thinking. Even if we understand it as a metaphor, it does not advance our understanding greatly, because it is not clear what that metaphor means. Great thinkers, philosophers, and mystics have offered different meanings. What can a modern jurist draw from this idea? Justice Alon did not try to explain the image of God theologically or philosophically. He tried to draw from it normative conclusions. I wish to dwell on his main conclusion, in my judgment. In the case of Gueda, he discussed the situation of search in a person who was suspect of holding dangerous drugs. The police officers called the suspect and asked him to be searched, and he agreed. The search involved the suspect taking off his pants. The question was whether the police officers accorded him due dignity, and whether his consent to their search exempted them from this responsibility. Justice Alon observed, the founding foundation of the supreme principle of human dignity is that man was created in the image of God. According to this worldview, he himself is commanded to keep his dignity. So if he gives his consent to humiliated search, it does not count. Because it is a duty also for him. He is commanded. Human dignity, which is based on the image of God, is not only a right, but it is also a duty. He elaborated this idea in an essay on the basic laws. In the world of Judaism, the source of human rights, including their entire details, is founded in the idea that man was created in the image of God. From this founding idea flow, first and foremost, human duties. As human dignity is not only a right of individual, but also his duty. A man is commanded and must not harm his own dignity and freedom because he must keep his own image of God. This conclusion has far-reaching implications. Take, for instance, the right to life or the right to freedom and so on. If it is not only a right but also a duty, then an individual cannot just give up his right, at least without a good reason. Eliyahu posits this view in contrast to the common liberal understanding of human rights. In the Western world, he writes, human rights are founded in the individual's autonomy and his right to self-determination. According to this view, an individual owns his rights and can give them up whenever he wants. This generalization of liberal theory of human rights is, however, not accurate. Some of the liberal theories of rights imply that rights, or some rights, entail also duties. Kantian approach, as a broad example, view human dignity also as a duty. But it is not only Kantians who believe in duties. In recent writings, there are different attempts to establish the idea that some rights function also as duties or responsibilities. In fact, the current discussion around the concept of human dignity is occupied a lot with this question of the relationship between rights and responsibilities, or rights and duties. I'll give one example. Professor Jeremy Waldron from NYU developed such theory in his book, Dignity, Rights, and Responsibility. His point of departure was that dignity carries with it also responsibilities. He took as an example the right of parents to raise and take care of their children. This right is at the same time responsibility. One may even say that the right is a precondition to fulfilling the responsibility. In the same way, Waldron suggests, human beings have a responsibility to develop their human dignity. The rights based on human dignity are preconditions to facilitate the fulfillment of one's human dignity. This line of thinking is very close to Elon's model of God's image. This line of thinking provides a positive content to the concept of human dignity, but it leaves many questions open. The main question is, what is the role of the state in this model? Should the state oversee the fulfillment of one's dignity, or should it be left to the individual? Some support the state involvement and argue that authorities must ban or limit certain activities, such as prostitution, in the name of human dignity. Others object to any limitation on human liberty in the name of dignity. As Waldron rightly wrote, the idea that rights may function also as duties does not determine the outcome of every case. We must think carefully about each problem and each particular dispute. We must assess whether the right before us implies or carries with it a duty, and what the proper balance between the right and the duty is. This insight might be true for the idea of God's image as well. The Elon's statement that God's image carries with it duties does not determine every case and the balance between duty and right. The two models we have seen with regard to human dignity reflect the two main models regarding the general relationship between Jewish law and Israeli law. Engel represents the model of separation between the two systems, while Elon represents the model of influence and absorption. Our discussion exposed, I hope, some of the problems in each model. The model of separation gives up from the beginning any possibility to maintain some connections between modern Israeli law and ancient Jewish law. This is, of course, a matter of cultural choice. The model of absorption struggles to absorb the terminology and the legal arrangements of Jewish law in every possible case. Sometimes, as in the case of human dignity, the model that Justice Elon built, to my judgment, was coherent, systematic, and impressive. But still, the relevance of religious terminology remains questionable. He failed to engage in a sincere comparison between Jewish law and modern law. In recent writings, several scholars called for developing a new model of relationship between Jewish and Israeli law. Some called it dialogic model, others called it critical model, and maybe others offer other names. The main point is maintaining the dialogue between Israeli law and Jewish law in a more sincere way, acknowledging the fact that the modern state cannot absorb Jewish law as is, but can always learn from it.
Thank you very much.